Is wholesaling legal in New York? Depending on who you talk to, you might get two different answers. Some people will tell you that they've been wholesaling for many years and it's 100% legal regardless of how you do it. Other people, including some attorneys, will tell you that it's either illegal or that it's a gray area and that you should stay away from it and come up with another way to make money in real estate. So I figured I'd do a video on this topic and try to break down some of the myths and also explain exactly what's legal and what isn't legal in New York. Coming up. Hey guys, my name is Vitaly Volpov. I'm a practicing attorney, an active real estate investor, and a part owner of a real estate brokerage in upstate New York. On this channel, I discuss relevant legal concepts as well as best strategies and tips for real estate investing. If you're new to the channel, consider subscribing and hitting the notification bell so that YouTube notifies you of all my future content. If you enjoyed the content in this video, hit the like button and comment down below. As always, whenever I talk about legal concepts on this channel, you should never construe that as legal advice. I provide this information for educational and entertainment purposes only, and you should always consult your own advisor and your own attorney before making any legal or financial decisions. I do not intend to create any attorney-client relationship with this video, and you should know that laws are constantly changing, and just because someone on YouTube was right about a law at the time they created the video doesn't mean they're going to be right when you're watching this video and you need to make a decision, which is why you need to consult with an attorney who's up on the laws and knows exactly what the current state of the law is. Now, before we talk about the legalities of wholesaling, let's first define the term. You guys may have heard me talk about wholesaling as assignment of contracts, but there are actually two different methods of doing wholesaling. One of them is assignment of contracts, and the other one is something called the double close. So let's define them. Assignment of contract is when you enter into a contract with a seller for a particular price, and then you assign your right to that contract to another buyer. That buyer then pays you a fee, and then they go and close on that contract with the seller. Method number two is the double close, where you get that property under contract with the seller for the same price, and then you go and close on that property, so you take title to the property, and you turn around and resell that property to the other buyer for a slightly higher price. Let's take a look at these two methods with a concrete example on the whiteboard. All right, let's talk about the assignment of contract method first. Let's assume that you found a property that is worth $200,000 after repair value. And let's also assume that it needs $20,000 worth of work. You end up going to the seller and you end up negotiating the lowest possible purchase price for that property that the seller will accept. And let's say that price is $100,000. So you enter into a contract with the seller for $100,000. And that contract contains what's called an assignment clause. And this is basically language in the contract that allows you to assign that property, the right to purchase that property, to another party. And so once you have that contract in hand and before you close on the property, you go and find another buyer who may be interested in the same property. And let's say this is the buyer here. This buyer wants to flip the property, and they look at the numbers, and you end up telling them, I will sell you this contract for $10,000. So that means that $10,000 will be your assignment fee, and the buyer will end up spending $110,000 plus closing costs to close on this deal. The buyer says, okay, that sounds good to me, signs a contract with you. This contract is the assignment agreement. Once you have both contracts in place, you schedule the closing, and the money ends up exchanging hands. The buyer pays the seller $100,000 and they pay you your $10,000 fee. In this case, the title to the property passes directly from the seller to the buyer. So that's the assignment of contract method. The other method that I mentioned is the double close method. Let's assume that everything is the same. You have the same property, it's the same after repair value, the same amount of repairs. You negotiate the same purchase price with the seller, $100,000, and you sign a purchase agreement with them. Once you have the purchase agreement and before you close on the deal, you end up going and finding another buyer. Let's say it's the same buyer as in the other example, and you go to them and you say, I'm about to close on this property and I'm going to resell it. Are you interested in buying it for, let's say, $115,000? The buyer looks at the numbers and they say, okay, that sounds like a good deal, and you end up signing another contract with them. So now you have two contracts, just as in the other example, but the second contract here is another purchase contract. It is not an assignment contract as in the other example. So what happens next is you end up buying this property from the seller, you actually close on the deal, and the title goes from the seller to you. Once you close on that deal, the next thing you do is you turn around and you sell this property to the buyer. This is another closing, a separate closing, where the title passes from you to this buyer. In both cases, you as the wholesaler are making about the same amount of money. In this case, you got a $10,000 assignment fee, whereas in this case, you sold the property for $115,000 after you spent $100,000 plus closing costs on both ends of the transaction. So roughly, your profit on this is probably about the same, about $10,000. Personally, my preference is for the assignment of contract, and that I think is what most wholesalers prefer. In this case, with the assignment of contract, you don't actually have to come up with any financing, you don't have a whole lot of risk. All you do is you get the transaction put together and you end up making your fee and walking away. You don't have to take title, you don't have to bother with any kind of insurance or title insurance or anything like that. Whereas here, you actually have to get $100,000 either financed or you have to pay the seller $100,000 in order to close on this deal. And you only get paid after you resell that property. So if something happens and this buyer decides to back out after you close on this deal, but before you sold it to them, now you're stuck with this property. You may not necessarily want to do any of the repairs on the property yourself or to try to flip it yourself, or maybe you don't have the expertise or any additional money to do that, and now you could be in the potential bind. For this reason, most wholesalers prefer the assignment method versus the double close method. So now that you know the definition of wholesaling and the general idea of exactly what's involved, let's talk about the legalities of wholesaling in New York. Let's first talk about the double close method. As I mentioned, this is the method where you take title to the property and then immediately turn around and sell it to another investor. As far as New York state law is concerned, there's absolutely nothing illegal about doing that. So you can do that all day long, as many transactions as you want, and you never have an issue as far as legalities go. Where you run into a problem is the other method, the more popular assignment method. And with that, it really matters how you hold yourself out in the transaction and your dealings with both the seller and the buyer. The law relating to this type of transaction is the New York State real property law relating to licensing of agents and brokers. Not surprisingly, the law prohibits anyone without a license to be acting as a real estate agent or broker. So in order to stay on the right side of the law, you need to understand what it means to be a real estate broker in a transaction. So let's look at the definition in the real property law to see what that actually means. Section 440 of the New York Real Property Law provides that a real estate broker means any person, firm, limited liability company, or corporation who for another and for a fee, commission, or other valuable consideration engages in a variety of real estate transactions. Now this section of the law lists all kinds of different transactions. It talks about listing for sale, selling, exchanging, renting, etc., etc. And it should come as no surprise that wholesaling is included in one of these categories. So does this mean that you can't wholesale and assign contracts unless you have a license? Actually, no. The law provides that you can't do this without a real estate license if you're doing it for another. And that's the key language. As long as you're not acting as a real estate agent or a real estate broker in a transaction, you don't have to be licensed. The problem for a lot of wholesalers, though, is that they do violate this provision, because what they're taught to do by a lot of gurus or books that they've read is to go to the seller and tell them, I can help you out of your difficult situation, whatever that is, and I'll find you a buyer, and in exchange, you can pay me a fee in the process. Well, when they do that, they're actually performing the work of a real estate broker and violating this provision. So how do you make sure that you're not violating this provision? Well, first of all, you should have a separate disclaimer paragraph in both your contract with the seller and your contract with the buyer. The paragraph should say that you're not representing the seller and the buyer in the other case, and that you're acting solely on your own behalf. You should also say that you're not a licensed real estate agent or real estate broker, and that you don't represent yourself to be one. That it is an arm's length transaction between two consenting parties relating to this property. As long as you do that, you shouldn't have a problem wholesaling a property through an assignment of contract method. And in case you're wondering, the penalties for violating this provision are pretty serious. Section 442E of the Real Property Law provides that even if you have a single violation of this provision, you may still be found guilty of a misdemeanor. I don't know about you guys, but I would never want a criminal conviction as a result of a real estate transaction. It's completely not worth it and extremely stupid. In addition to criminal penalties, there are also potential civil penalties. The same section allows the seller or the buyer or the attorney general to sue you for damages. And the damages are calculated based on the amount that you made on the transaction. In addition to the amount you made on the transaction, you may also have to pay penalties up to 3 times the amount that you made. So in a transaction where you made $10,000 as a fee, you may have to repay that fee and then pay an additional $30,000 in penalties. Again, it definitely makes sense to make sure that you're doing this the right way and that you're not exposing yourself to criminal liability or severe civil penalties like this. I know what some of you guys are thinking. If not having a real estate license is a real issue here, why don't I just go and get my real estate license and then I can wholesale and do assignments of contract as much as I want? Well, generally I would agree with you, and you probably should go and get your real estate license if you're involved in real estate. I actually did a video on this not too long ago, and I'll link it in the description below so you guys can see the pros and cons of getting your real estate license as a real estate investor. But when it comes to wholesaling, there is another obstacle. If you do go and get your real estate license, you still have to make sure that you're acting on behalf of yourself when you're doing wholesale transactions. And it doesn't really help you to have a real estate license for that purpose. The reason is that the New York State real property law prohibits something called a net listing for licensed agents. And a net listing is basically an agent going to their client and telling them, I'm going to get you the price that you want, and then anything over and above that price that I sell the property for, I get to keep as my commission. This is not something that's allowed, and actually agents can get in a lot of trouble and potentially lose their license if they do this. So if you go and get your real estate license, you still have to make sure that you're doing your wholesale deals on behalf of yourself alone. And you may actually have additional disclosure requirements as a real estate agent, because not only will you have to tell them that you're not representing them, but also that you are a real estate agent, and it certainly makes things a little bit more complicated. I'm not saying that you shouldn't go and get your real estate license if you're going to be doing wholesaling. I am saying that you still have to be careful and that it's not necessarily a solution to this particular problem. So that's going to do it for this video, guys. If you enjoyed it, if you got value from it, do me a favor and hit the like button. These videos take me a long time to put together and research, so I definitely appreciate all of your support. And if you haven't yet subscribed to the channel, subscribe so that you don't miss any of my future videos. Have a great day, and I'll see you in the next video. Take care.